Ms. Minute-Phillips.
May it please you, my lords. I'd like to start my very brief reply by just clarifying something that emanated from my friend's address to the court. In the course of his submissions, the court asked him whether or not declarations filed by the specified persons in public life would be published or available to the press, and he answered yes. That is not so, my lords. If you look at section 47 on MS 334, you will see under a heading called Duty of Secrecy, every member of the Commission and every person performing any function in the service or as an employee of the Commission shall treat all records and information relating to declarations as secret and confidential, and shall not disclose or communicate the text of any record or information or declaration to any unauthorized person, or to allow any unauthorized person to have access to any records, information, or declarations. And if you look at section 97, which is on page MS 355, that duty of secrecy is buttressed with an additional duty of confidentiality. And at 97.1, it states any information received by any member, officer, or other employee of the Commission in the course of the performance of the functions of such person under this ordinance, including information contained in any document received by that person by virtue of the provisions of this ordinance, shall not be divulged by any such member or by any such officer or employee, except where the information is required to be produced for the purpose of complying with any written law or the order of any court, or for the purpose of prosecution for an offense. So there is not only a duty of secrecy, there's also a duty of confidentiality. So the material in the declarations is not available to the public. What the public may be able to search is a register of interests of members, but certainly not the declarations filed by the declarants, which was the subject of this summons in this case. And that's
So the register of interest, which section is that?
The register of interests, had it here just a moment ago. Just one moment, my lords.
Thank you.
MS 337, my lords. Section 54, 338, register of interest, 338, not 337. And on that, when you go back to the Constitution, you will see right under section 102 is section 103, which deals with the registering of interests. So, and that also falls under the head of the Integrity Commission in the Constitution. So the register of interest is different from the declarations filed by members.
But doesn't the register of interest contain all the information in the declaration?
No, my lords, it does not. It does not. I think it relates to your interest in contracts, certain contracts, or your interest in a company, if you're a shareholder, that kind of thing. Yes, it's right above in section 53, subsection 1. You see what is in the register of interest there, my lord.
Okay.
So there is no danger of the public getting access to any information provided to the Commission by Mr. Kikivarakis in answer to the summons. The other thing I would wish to mention in my reply, my lords, my friend in his written submissions refer to the case of Hazel and Hammersmith. It turns out not to be really relevant now that he has conceded that there's no distinction to be drawn between functions and powers, or no material distinction for these purposes. But there is a quote in there that I would like to bring to your Lordship's attention at MS page 463. Page 554 of the case, which is at MS page number 463. And it is a quote from the Lord Chancellor Selborne at letter D on the doctrine of ultra-vires, where he says the doctrine of ultra-vires ought to be reasonably and not unreasonably understood and applied, and that whatever may fairly be regarded as incidental to or consequential upon those things which the legislature has authorized ought not, unless expressly prohibited, to be held by judicial construction to be ultra-vires. And I commend that dicta to your Lordships, because that's what has happened here. There is no express prohibition against the Integrity Commission in issuing a summons, but its actions in doing so, although expressly authorized by the Section 20 of the Act, have been by judicial construction declared to be ultra-vires.
That does leave the question whether it should be regarded, such a power should be regarded as incidental to or consequential upon matters which haven't really been addressed.
Yes, but the power is an express one. It's not something that needs to be inferred. So I don't think it is capable of any other conclusion that it is incidental to or consequential upon. The final thing, my lords, my friend referred to, the only other authority that I recall my friend referring to that I had not mentioned was the Commissions of Inquiry Act, and I don't think I need to go there because my submission was that the Commissions of Inquiry Act allows the issuance of a summons for the purpose of carrying out the terms of reference of the Commission of Inquiry, and I said that was the same thing that applied under the Integrity Commissions Act. It allows for the issuing of a summons for the purpose of carrying out the terms of reference of the Integrity Commission, which terms of reference are set out in Section 13 and include Section 43. Well, that's there, unless there was any other authority that you wished me to speak on, that then would be the reply on behalf of the appellant.
Thank you. Thank you, Ms. Maynard-Phillips. There are no questions. We're grateful. We are very grateful to both counsel for your submissions in this matter, and we're also grateful to those who've assisted you in the preparation of the case. The board will now take time to consider what advice they will humbly tender to Her Majesty. The court is now adjourned. Thank you very much.